Hello students, welcome to the lecture on the Hotelkeeper and the law of contract. And after this lecture, we will be able to learn the following objectives. Explain the meaning of contract, define the meaning and essential of valid contract, discuss privity of contract and classification of contracts, describe offer and acceptance and competent to contract, explain the meaning of fraud and breach of contract. Let's start with the introduction. The law of contracts is the basic upon which the superstructure of all business is built. It affects every person in one way or the other, as all of us enter into some kind of contract every day. All contracts are based on agreements which are either express or implied. Every one of us enters into a number of contracts almost every day. Most of the time, we do so without realizing what we are doing from the viewpoint of law. A person seldom realizes that when he gives clothes for dry cleaning, or when he buys milk, bread or biscuit, or when he goes to the auditorium to see a movie, he is entering into a contract. Let us now discuss the meaning of contract. The word contract is derived from the Latin contractum, meaning drawing together. According to the Act, an agreement enforceable by law is a contract. An analysis of these definitions would show that a contract must have the following two elements: an agreement and its enforceability, legal obligation. Agreement. According to the Act, every promise and every set of promises forming the consideration for each other is an agreement. Now the question is, what is a promise? According to the Act, a person when accepted becomes a promise. Agreement is equal to proposal or offer plus acceptance of proposal or offer. An analysis of the definition of the term agreement shows the following two characteristics of agreement. Plurality of person. There must be two or more persons to make an agreement. Consensus ad idem. Both the parties to an agreement must agree about the subject matter of the agreement in the same sense and at the same time. Enforceability of agreement. An agreement is enforceable by law if it creates some legal obligation. In other words, the parties to an agreement must be bound to perform their promises. In case of social or domestic agreements, the usual presumption is that the parties do not intend to create legal relationship. Let us now discuss the meaning and essential of valid contract. A contract is an agreement that can be enforceable by law. An agreement is an offer and its acceptance. To be enforceable by law, an agreement must possess the essential elements of valid contracts. All agreements are contracts if they are made by the free consent of the parties competent to contract for a lawful consideration with a lawful object, are not expressly declared by the Act to be void, and where necessary satisfy the requirements of any law as to writing or attachment or registration. Offer and acceptance. There must be a lawful offer and a lawful acceptance of the offer, thus resulting in an agreement. The adjective lawful implies that the offer and acceptance must satisfy the requirements of the Contract Act in relation thereto. Intention to create a legal relation. There must be an intention among the parties that the agreement should be attached by legal consequences and create legal obligation. Agreements of a social or domestic nature do not contemplate legal relations, and as such they do not give rise to a contract. Lawful consideration. The third essential element of a valid contract is the presence of consideration. Consideration has been defined as a price paid by one party for the promise of the other. An agreement is legally enforceable only when each of the parties to it gives something and gets something. Capacity of parties. The parties to an agreement must be competent to contract. But the question that arises now is that what parties are competent and what are not. The contracting parties must be of the age of majority and of sound mind and must not be disqualified by any law to which they are subject. Free consent. Free consent of all the parties to an agreement is another essential element. This concept has two aspects. Consent should be made and it should be free of any pressure or misunderstanding. Lawful object. For the formation of a valid contract, it is also necessary that the parties to an agreement must agree for a lawful object. The object for which the agreement has been entered into must not be fraudulent or illegal or immoral or opposed to public policy, or must not imply injury to the person or the other, or the reason mentioned above the agreement is void. Writing and registration. According to the Indian Contract Act, a contract to be valid must be a writing and registered. Certainty. Section 29 of the Contract Act provides that agreements, the meaning of which is not certain or capable of being made certain, are void. In order to give rise to a valid contract, the terms of the agreement must not be vague or uncertain. Possibility of performance. Yet another essential feature of a valid contract is that it must be capable of performance. Section 56 lays down that an agreement to do an act impossible in itself is void. Let us now discuss privity of contract. A contract is an agreement between two or more parties that creates an obligation to do or not to do something. The parties to the contract are under an obligation to perform the terms and conditions as laid down in the contract. Thus, a contract can confer rights or impose obligation arising under the contract on the parties to the contract. Third parties cannot be under such an obligation to perform or demand performance under a contract. This is referred to as privity of contract. Exceptions to general rule of privity. If the doctrine of privity was inflexibly applied, it would cause considerable injustice and inconvenience. Many exceptions to it have thereof been developed. Collateral contracts. A contract between two parties may be accompanied by a collateral contract between one of them and a third person relating to the same subject matter. Agency. The concept of agency is an exception to the doctrine of privity in that an agent may contract on behalf of his principal with a third party and form a binding contract between a principal and third party. Trust. Equity developed a general exception to the doctrine of privity by use of the concept of trust. A trust is an equitable obligation to hold property on behalf of another. The device was approved by the House of Lords in Les Affriteurs Re Unis v. Leopold Walford, where a broker C negotiated a charter party by which the ship owner A promised the charterer B to pay the broker a commission. It was held that B was trustee of this promise for C, who could thus enforce it against A. Restrictive covenants. Restrictive covenants may, if certain conditions are satisfied, run with the land and bind purchaser of it to observe the covenants for the benefit of adjoining owners. Statutes. Certain exceptions to the doctrine of privity have been created by statute, including price maintenance agreements and certain contracts of insurance enforceable in favor of third parties. Remedies of the contracting party. The question of the extent to which a contracting party may recover for loss sustained by a third party who is intended to benefit from the contract was raised in Jackson v. Horizon. Holidays. The plaintiff entered into a contract for himself and his family. The holiday provider failed to comply with the description given by the defendants in a number of respects. The plaintiff recovered damages and the defendants appealed against the amount. Quasi-contracts. A quasi-contract, also an implied in-law contract, is a legal substitute for a contract. A quasi-contract is a contract that should have been formed even though in actuality it was not. It is used when a court wishes to create an obligation upon a non-contracting party to avoid injustice. Kinds of quasi-contracts. The various kinds of quasi-contract or quasi-contractual obligation are: claim for necessaries supplied to a person incapable of contracting or on his account. If a person incapable of entering into a contract or anyone whom he is legally bound to support is supplied by another person with necessaries suited to his condition in life, the person who has furnished such supplies is entitled to be reimbursed from the property of such incapable person. Reimbursement of person paying money due by another, in payment of which he is interested. A person who is interested in the payment of money which another is bound by law to pay, and who therefore pays it, is entitled to be reimbursed by the other. Obligation of person enjoying benefit of non-gratuitous act. where a person lawfully does anything for another person or delivers anything to him, not intending to do so gratuitously, and such other person enjoys the benefit thereof, the latter is bound to make compensation to the former in respect of or to restore the thing so done or delivered. Responsibility of finder of goods. A person who finds goods belonging to another and takes them into his custody is subject to the same responsibility as a bailee. Liability of person to whom money is paid or thing delivered by mistake or under coercion. A person to whom money has been paid or anything delivered by mistake or under coercion must repay or return it. Discharge of a contract. Discharge of a contract means termination of contractual relationship between the parties to a contract. In other words, a contract is discharged when the rights and obligation created by it are extinguished, that is, comes to an end. Discharge by performance. Fulfillment of obligation by a party to the contract within the time and in the manner prescribed in the contract. Actual performance. No party remains liable under the contract. Both the parties perform. Attempted performance or tender. Promisor offers to perform his obligation under the contract, but the promise refuses to accept the performance. Discharge by mutual agreement. Novation. Novation means substitution of a new contract in the place of the original contract. New contract entered into a consideration of discharge of the old contract. All the parties must consent to novation. The novation must take place before the breach of original contract. The new contract must be valid and enforceable. Rescission. Rescission means cancellation of the contract by any party or all the parties to a contract. X promises Y to sell and deliver 100 bales of cotton on 1st October is gone down, and Y promises to pay for goods on 1st November. X does not supply the goods. Y may rescind the contract. Alteration. Alteration means a change in one or more of the terms of a contract with mutual consent of parties. The parties of new contracts remains the same. Discharge by operation of law. Debt. Involving the personal skill or ability, knowledge of the deceased party, one discharge automatically. Insolvency. When a person is declared insolvent, he is discharged from his liability up to the date of insolvency. By unauthorized. Material alteration. Without the approval of other party comes to an end. Nature of contract, substance or legal effect. Merger. When an inferior right accruing to a party in a contract merges into a superior right accruing to the same party, then the contract conferring inferior right is discharged. Rights and liabilities vest in the same person. Where the rights and liabilities under a contract vest in the same person, the contract is discharged. Discharged by lapse of time. When a party fails to take action against the other party within the time prescribed under the Limitation Act 1963, all his rights to come and end. Recover a debt. 3 years recover an immovable property. 12 years discharge by breach of contract. Failure of a party to perform his part of contract. Anticipatory breach of contract. Anticipatory breach of contract occurs when the part declares his intention of not performing the contract before the performance is due. Actual breach of contract. If party fails or neglects or refuses to perform his obligation on the due date of performance or during performance, it is called as actual breach. Discharge by impossibility performance. Effect of initial impossibility. Effect of supervening impossibility. Classification of contracts. Contracts can be classified on a number of bases. Contracts on the basis of creation, express contract, implied contract, quasi-contracts, unenforceable contracts. Classification on the basis of execution, executed contract, executory contracts, partly executed and executory contract, bilateral contracts, unilateral contracts. Classification on the basis of formality, formal contracts, simple contract, contracts on the basis of enforceability, valid contract, void agreement, voidable contract, illegal agreement, unenforceable contract, special contract. There are some special contracts as contract of indemnity. An indemnity contract arises when one individual takes on the obligation to pay for any loss or damage that has been or might be incurred by another individual. Modes of contract of indemnity: expressed, implied. Essential elements of a contract of indemnity. Contract. All the essential of a valid contract must also be present in the contract of indemnity. Loss to one party. A person can indemnify another person only if such other person incurs some loss or it has become certain that he will incur some loss. Indemnity by the promisor. The purpose of contract of indemnity is to protect the indemnity holder from any loss that may be caused to the indemnity holder. Reason for loss. The contract of indemnity must specify that indemnity holder shall be protected from the loss caused due to action of the promisor himself or action of any other person or any act, event or accident which is not in the control of the parties. Rights of indemnity holder. Right to recover damages, right to recover cost, right to recover sums paid. Offer and acceptance. A contract is formed when the parties are taken to have agreed. It is the moment of agreement that prior negotiation, preliminary exchange of ideas or proposal, bargaining discussions become a legally binding contract. Offer. An offer must be distinguished from mere willingness to deal or negotiate. Essentials of a proposal. The definition of the word proposal given in the Act reveals the following three essentials of a proposal. The expression of willingness to do or to abstain from doing something. This expression must be to another person. This must be made with a view to obtaining the assent of the other person. Legal rules regarding a valid proposal. A valid proposal must be in conformity with the following rule. Express or implied, a proposal may be made either by words or by conduct. Lapse and revocation of proposal. A proposal lapses and becomes invalid in the following circumstances. An offer lapses after stipulated or reasonable time. A proposal lapses by not being accepted in the mode prescribed or if no mode is prescribed in some usual and reasonable manner. Acceptance. Acceptance occurs when the party answering the offer agrees to the offer by way of a statement or an act. Essential of a valid acceptance. Section 7 and 8 of the Act lay down following rules to convert a proposal into a promise. Acceptance must be absolute and unqualified acceptance must be expressed in some usual and reasonable manner. Mental acceptance is not sufficient in law. General rules of acceptance. Acceptance must be firm and final. The acceptance must be communicated. An offer can only be accepted by the offeree. An offer must be in response to the proposal. Correspondence with offer. Revocation of an offer should be done before acceptance. Competent to contract. One of the essential elements of a valid contract is that the parties to the contract must be competent to contract. An agreement becomes a contract if it is entered into between the parties who are competent to contract. Who is a minor? As per the Indian law, a person domiciled in India who is under 18 years of age is a minor. Position of agreements by minor. The law regarding minors' agreement may be summed up as under. An agreement by a minor is absolutely void and inoperative as against him. No restitution except in certain cases. Beneficial agreements are valid contracts. No ratification on attaining the age of majority. The rule of estoppel does not apply to a minor. Contracts by minor. Rules relating to a minor's contract. According to Section 3 of the Indian Majority Act 1875, a minor domiciled in India is one who has to complete his 18 years of age. But in cases where a guardian of the minor's person or property or both is appointed or where a minor's property is taken over by a court of wards, the minority continues up to the completion of his age of 21 years. Contractual capacity. The minimum mental capacity required by law for a party who enters into a contractual agreement to be bound by it. Meaning of fraud. A false representation of a matter of fact, whether by words or by conduct, by false or misleading allegation, or by concealment of what should have been disclosed, that deceives and is intended to deceive another so that the individual will act upon it to her or his legal injury. Fraud consists of 5 elements: the making of a false statement with knowledge that a statement is false or with reckless disregard as to whether or not the statement is false or true, with the intent that the listener rely on the statement, with the result that the listener relies on the statement, with the consequence that the listener is harmed. Breach of contract. Breach of contract is a legal term that describes a violation of a contract or agreement in which one party fails to fulfill its promises or by interfering with the ability of another party to fulfill its duties. A contract may be breached in whole or in part. Defenses to breach of contract. A defendant may offer a reasoned defense why the alleged breach is not really a breach of contract. Remedies for breach of contract. If one party is found to be in breach of a contract, the plaintiff has several ways to be made whole, called a remedy. The most common remedy is monetary payment. Some other common remedies for a loss resulting from a breach of contract are: remedy means course of action available to an aggrieved party when other party breaches the contract. Rescission of contract. It means right to party to cancel contract. In case of breach of contract, other party may rescind contract. Effect of rescission of contract. Aggrieved party is not required to perform his part of obligation under contract. Aggrieved party claims compensation for any loss. Types of breach of contract. Material breach is a breach that is significant enough to excuse the aggrieved party from fulfilling its part of the contract. Partial breach, a failure to satisfy or meet a term of a contract which is so minimal that it does not cause the contract to fail, also referred to as an immaterial breach. Anticipatory breach, a party may breach a contract by doing or failing to do something that shows intention not to complete duties under a contract. Discharge of contracts by breach. A contract may in some circumstances be discharged by a breach of contract. Where there exists a breach of condition as opposed to breach of warranty, this will enable the innocent party the right to repudiate the contract, bring the contract to an end in addition to claiming damages. Now in the end, let us summarize what we have learned in this lecture. An essential element in proving fraud is to provide that one relied on the statement which is alleged to be fraudulent. An agreement becomes a contract if it is entered into between the parties who are competent to contract. The right to indemnity and the duty to indemnify ordinarily stem from contractual agreement which generally protects against liability, loss or damage. Breach of contract is a legal term that describes a violation of a contract or agreement in which one party fails to fulfill its promises or by interfering with the ability of another party to fulfill its duties. Material breach is a breach that is significant enough to excuse the aggrieved party from fulfilling its part of the contract.